I'm Megan Gibb and I'm a solicitor in the matrimonial and childcare departments. I qualified in December 2023 and specialise in all matters relating to children. I work in the Waterlooville office. Some parents are entitled to legal aid in child arrangement disputes. There are certain conditions that need to be fulfilled for the legal aid agency to be satisfied that you have either been a victim of domestic abuse or the child is at risk or has suffered domestic abuse. So you can either, one of the parents can be a victim themselves or the child can be at risk. So there are multiple ways that you can evidence this. You can have letters from charities such as Stop Domestic Abuse, and you can also have letters from GPs that confirm that in their professional opinion they have assessed you as being entitled for legal aid. There are then also other ways that you can be entitled to legal aid. So for instance, if you have local authority involvement and your child is subject to a child protection plan, then you would also be entitled to legal aid for the domestic abuse side of things. And if your child has been assessed at being at risk and you have evidence in the form of a letter from Children's Services, that would also make you eligible for legal aid as well. Once you've shown the evidence part for the domestic abuse or the child being subject to a child protection plan, you would then be means and merits tested, and you would be required to come into the office and provide us with evidence of your means. So we would ask for bank statements for all banks, any information about any property you own, and then we would also assess whether your case would be successful and would then let you know whether or not you would be entitled to legal aid. If you have children with an ex-partner or just someone that you're not in a relationship with and the child has been residing with the other parent and that other parent is refusing to allow you to have contact with that child, then there are a range of options that you can take. First of all, you could attend mediation. This isn't always relevant for all parties, and if you've been a victim of domestic abuse, it may not be appropriate for you to engage in mediation. There is also the option of speaking with the other parent and seeing if you can reach an amicable agreement. However, if they are point blank saying that they will not let you have any contact with the child, then it's unlikely that this would be effective. If mediation and speaking with the other parent isn't successful, then it would be worthwhile instructing a solicitor and seeking some legal advice. Your solicitors may suggest that they write to the other parent and they put forward your proposals, or they may advise you to apply to court for a child arrangements order. Now, if the other parent is refusing you to have contact with the child, then you would need to apply to the court on a C100 form asking for the court to deal with the child arrangements and or to make a live with order in your favour. If your child is not having contact with you at the moment due to the other parent refusing contact, then I would suggest that you seek independent legal advice, and we are more than happy to help you and assist you at churches. At churches, we appreciate that not all parents are in a financial situation to pay for representation at court proceedings. We therefore are happy to assist our clients at a free 15-minute drop-in session, or we can assist clients on a self-help basis, which means that we would take the initial client meeting with them, would give them some initial client advice, and then would help them with any further parts of the proceedings that they needed help with. So for instance, if a client needed help drafting a statement and they wanted to just ensure that it was persuasive and dealt with everything that it needed to, then we would be happy to review that for them and give them advice on that particular statement, and we wouldn't be on record as acting. So that's a way to ensuring that they receive legal advice and know what will happen throughout the proceedings, but it will keep their costs to a minimum.